Hello, everyone. My name is Callie Siplin, and I am the graduate assistant for the Sacramento State debate team, and I am going to be your moderator for our debate tonight. Before we begin, let's get a lay of the land. So the Sacramento State debate team puts on a public debate and public forum every semester as a representation of what the debate team does and to introduce the art of speech and debate to the public. Tonight, we'll be debating the topic, the United States federal government should amend Section 230 of the Communication Decency Act of 1996 to allow for civil liability for misinformation. To summarize, our debaters will be talking about Section 230, a bill that introduced the concept of social media companies not being legally responsible for the content of their users produced, with the exception of specific crimes such as human trafficking. Tonight, we have some of our talented debaters lined up as our affirmative team and our negative team. On our affirmative team is Giovanni Salgado, Ariela Sotelo, and David Kirker. On our negative team, we have Estefany Olivieres, Kelly Williams, and Aya Al-Jabouri. Tonight, we will have the affirmative speak for 5 minutes, followed by a cross-examination by our negative team, and then the negative will speak for 5 minutes. This will continue. I will be timing the debaters and cutting them off after their allotted time. Without further ado, I invite both teams to turn their cameras on, and the affirmative team, you are welcome to begin the debate.
Okay, hi. Before I begin, I just want to say thanks for being a part of the debate. I am the affirmative today. My name is Giovanni. And one of the most controversial issues at hand today is the spread of misinformation online and its effects of what is published on its effects on American society. Various events in 2021 have brought into question what should be allowed to be published online and who, if anyone, should be held liable for the effects of what is published online. Our first contention is that misinformation can lead to violence, as shown by the events in 2021, the January 6th storming of the Capitol, which is a prevalent example of the power of the spread of misinformation. Furthermore, our second contention is the rampant spread of misinformation regarding COVID-19 and the vaccine on social media have become an overwhelming threat to public safety and, as a result, a health crisis. This has forced the federal government to look at how to push for social media platforms to include more oversight of what is being published on their platforms. But one piece of legislation stands in their way. And it is essential to understanding the issue at hand. It is Section 230 of the 1996 Communications and Decency Act. Section 230 states, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. According to an article by the Information Technology and Innovation Foundation, in practice, this essentially means that online services are not liable for defamatory or otherwise unlawful content made by their users on their platform. Many attribute that this is the reason for why many of the social media platforms that exist today are able to exist without being held liable for the content of their creators. According to an article on CNN, one of the senators who actually co-authored Section 230, Ron Wyden, says this law was created during the rise of the internet. He essentially characterized the creation of this law as a result of various lawsuits in the 1990s at a time which had no real law to apply when considering who to hold liable for the content published on a website. One of the landmark lawsuits which influenced the creation of Section 230 occurred during the 1990s and is attributed to one of the most famous and controversial brokerage firms, Stratton Oakmont. Yes, like from the movie starring Leonardo DiCaprio from The Wolf on Wall Street. They decided to sue Prodigy Internet Services for defamatory posts their users made. Even during the early days of the internet, the courts had ruled very much in favor of maintaining platforms that hosted third-party content not liable for the content. But in the case of Stratton Oakmont versus the Prodigy, the courts did hold Prodigy liable for the content posted on their platform. This is due to the fact that Prodigy was actively making an effort to moderate the information posted on their platform, and by failing to moderate the defamatory and anonymous posts, became liable to the contents of the post. Furthermore, this decision was widely unpopular as it essentially promoted the internet platforms that were moderating content in good faith could be held liable for their inability to properly moderate all of the content made by third-party users. This presented a clear problem for rising platforms that allow third-party content. This is where the answer to Section 230 comes into play. Senator Wyden describes this law as providing for platforms that allow for third-party users to post content such as Prodigy with a sword and shield. Essentially, this shield of Section 230 is the protection that it provides for social media companies such as Twitter for the contents of their users' posts, which had already become standard conduct by the time the 1996 Communications and Decency Act was proposed. Furthermore, Senator Wyden describes the sword as a protection that is provided to internet platforms that protects them from being held liable for how they choose to approach moderating content, a keystone part of Section 230, which paved the way for the creation of social media as we know it today. This is due to the fact that it allowed new platforms to focus much more on creating and establishing their platform rather than focusing on how to moderate it. Furthermore, Section 230 was essential in helping establish the internet as we know it today, but has resulted in a complete failure of content moderation in regards to misinformation. According to an article in The Atlantic by Steve Randy, in 1996, when Section 230 of the Communications and Decency Act was established, the idea of monopolies in the internet was ludicrous. Nonetheless, 25 years later, the internet is clearly a different place. Section 230 provides protection for services like Facebook, YouTube, Twitter, etc., and has created a culture for these companies to essentially use algorithms that keep individuals interested in returning to the platform without creating incentives for the company to find ways to moderate the misinformation. Thank you.
Wonderful. Thank you very much, affirmative team. Negative team, you may now begin your cross-examination. Remember, you have 2 minutes for your cross-examination. Negative team, we can't hear you. You're still muted.
I apologize for that, but I would like to ask the affirmative team to please elaborate on Section 230 and its impact it has to the public.
So Section 230 essentially states that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. And essentially the way this impacts the public is that misinformation that can mislead someone from their beliefs, such as COVID-19 and vaccine information, as a result of Section 230, can be up on the publisher's site, can be up on Facebook, and no one can be held liable for the misinformation and the damage that it causes.
So another question is, how would the 230 reform help with misinformation?
That's an excellent question, Kelly, but we'd like to answer it by saying that now there is a civil opportunity for people who can provide a causable link to harm from this misinformation to get the justice they deserve through the civil court system.
So I guess based on that answer, this civil opportunity to recover from harm, would this be for anything? Would this be for defamatory statements as well as misinformation, or what exactly? And how would somebody highlight harm?
So it would have to be in the form of a causable link. Like, for example, if someone promoted, some unnamed podcaster promoted ivermectin, and somebody took that information as viable and decided to take ivermectin, and they still got serious harm from COVID, that would be a causable link to say, look, this disinformation was disseminated. I know exactly who put it out there. And those individuals can no longer just hide behind Section 230. And now the people who brought that misinformation to light can now be held liable for a causable link if someone can actually prove they were harmed by this.
Wait, and I'm confused a little bit. Oh.
That is your time for the cross-examination. Negative, excuse me. Negative, you may begin your first speech. You have 5 minutes.
Good evening. I want to thank everybody for coming to tonight's debate. Tonight, I will be discussing the real issues of social media, misinformation, and my opponent's proposal to tackle it. While my opponent's proposal may be made with good intentions, the road to hell is usually paved with good intentions, and there are major censorship concerns that need to be addressed with regards to their proposal. I will be presenting 2 major counter arguments for the affirmations proposal, along with direct refutation of their evidence. let's talk about contention 1, the First Amendment presented. According to Mary Ann Frank, professor of law at the University of Miami and president of the Cyber Civil Rights Initiative, to the extent that people want to force social media companies to leave certain speech up or to boost certain content or ensure any individual continuing access to a platform, their problem is in Section 230. It's their First Amendment. The issue with reforming Section 230 is that it is likely to present a Supreme Court challenge under the First Amendment. This would allow the government to argue for looser restrictions on censorship. Any issue that the government determines a safety issue may be subjected to censorship. In order for proposals such as this to survive a legal challenge, the court will need to substantially expand expectations of the First Amendment, and that could substantially have negative consequences. James Grimland, a law professor at Cornell Tech, expands on this issue, stating that Section 230 is a main battlefront in a new and confused proxy war over the First Amendment. Jeff Kosef, an assistant professor of cybersecurity law at the United States Naval Academy, the author of the 26 Words That Created the Internet, a history of Section 230, provides a lot of analysis on how the weakening of the First Amendment might play out. He states that nearly all misinformation is protected by the First Amendment, and that allowing for truth determinations to be a metric of First Amendment protection. Contention 2, slaping down dissent. My next contention is about the damage done by private actors who are given free rein to sue. Currently, the strong protections from Section 230 make online platforms uniquely powerful sanctuaries for criticizing the powerful. The resolution would change that by opening internet speech to a dangerous phenomenon known as SLAPS, which stands for Strategic Lawsuits Against Public Participation. SLAPS disguises themselves as personal injury or defamation cases. According to a nonprofit organization, Protect and Protest, SLAPS targets First Amendment's activity, exploits powerful imbalance, threatens bankrupting levels of remedy, and name anyone tangentially related to the target. The point is intimidating into silence. Because there are no federal laws against using civil suit to intimidate, slappers will pick and choose which jurisdiction they start to sue. Even worse, they may use federal RICO laws intended to fight against crime, which allows triple challenges. The result of this is that online platforms will intimidate against hosting speech that criticizes the powerful, celebrities, corporations, and public officials. Again, activist groups won't be able to organize Facebook or Reddit. Hashtags will quickly get taken down or blocked on Twitter, and all dissentless mass movement power of social media will be gone overnight. No more hashtag Black Lives Matter, no more hashtag Me Too, no more future movements. If this is not enough to convince you, then perhaps we should discuss the cost. The most common legal foundation of SLAP suits is tort law. The Institute of Legal Reforms estimates the litigation cost alone of torts in 2016 was $184 billion. Even small increase in SLAPs would result in massive costs. What's worse is that there are no counsel for civil cases, no public defendants against SLAPs. If defendants can't pay exorbitant cost of lawyers' fees, then they have to represent themselves in the ancillary and bicentennial legal system, a battle they're almost sure lose without years of training and experience. Thank you.
All right. Affirmative, you can now begin your cross-examination.
First question. All right. Thank you so much for that wonderful speech, Stephanie. But I have a few questions for you, then I'll pass it to my teammates. First up, is the First Amendment absolute?
It is. I'm sorry.
The First
No,
Amendment is, oh,
I'm sorry.
what's your, What's your
No,
answer?
no, it's not.
It's not absolute. Okay. One small follow-up question. Do you think Twitter was justified in taking down former President Trump's account on January 8th?
As Twitter was.
You think it was justified? Okay. Thank you so much. You guys have any questions?
Can you further explain your slap argument to me?
I'm actually going to hand this over to one of my teammates.
So the slap argument is pretty straightforward. We argue that because Section 230 specifically protects individual corporations, specifically social media platforms, from being civilly liable for speech put on their platform. Repeal or reform of it would functionally make these corporations publishers of every piece of information that is published on their site. The slap suit argument is that by holding these companies civilly liable, other people can use lawsuits and civil liability to intimidate corporations into overcorrecting and over censoring speech. So for a perfect example, with regard to the Me Too movement, or like very powerful people who are accused of sexual abuse publicly on public platforms, they can now intimidate companies into censoring that speech preemptively.
Can
As
you
it is
elaborate
defined.
on who they is in that
So
last
specifically
statement?
people who have the resources to pursue legal action. So the wealthy in our country can actually abuse this system of civil liability and have done so in the past and can continue to do so. This
And
opens the floodgates.
Couldn't you consider the people of power here in that sense, these large corporations?
time for the cross-examination,
Thank you.
of course. Affirmative, you may now begin your second speech.
I am here to continue speaking about the affirmatives plan that the United States federal government should amend Section 230 of the Communications Decency Act of 1996 to allow for civil liability for misinformation. I would like to begin first by addressing the negative team's argument. I would like to address their first contention. They make this argument that this becomes an issue for the First Amendment and basically a claim of censorship. The First Amendment is not absolute, which they also agreed to. It never has and never will be because it's often challenged and purview is changing at all times. Now, I'd also like to address their second contention, which was slap suit. My opponents claim that the policy is an abuse of power, stating that it essentially takes away the ability for the public to criticize those in power. We say that those in power, such as in this instance, these large platforms, will have to be held accountable, which they currently are not, for these damages. These major consequences are ones that will not be exempt for these big corporations, but this amendment must be made to 230. These entities are private corporations and should be held responsible to regulate themselves or allow for parties to go and check. Now, I'm just going to delve into more of our contentions and just tell you how we simply outweigh the negatives case here. Our first contention is that misinformation can lead to violence, which of course we are speaking in terms of Section 230. According to an article from the Pew Research, where they did a survey of July 13th through 19th, they said that 2/3 of Americans, which is 64%, say social media has a negative effect on what's happening in this country today. This is quite a large number. And they also say that the misinformation can lead to hate speech, right? they are not trusting the information. And that's for a good reason, which everyone has the ability to post whatever. We say that these platforms of misinformation lead to hate speech, fear, and transpire into beyond what the screen has held and can lead to violent behavior that has become very familiar over this past year, such as the displays on January 6th. Our second contention of misinformation can lead to public health crisis is that COVID-19 is probably the first thing that comes to mind when we all hear our second contention. This past year, we were able to see how these platforms, in addition to these large followings and people that have these large followings or viral posts, can affect the public's perspectives on public health. We have seen that through the lack of belief in the validity of the coronavirus and even the effectiveness of alleged agendas that people have brought up, that we've seen celebrities and even nurses posting their beliefs on social media and making it as if it's some sort of expertise. Lee Kumke, a professor of health communications at Harvard, discussed his opinion on this matter, stating that social media platforms are one of the most significant abettors to spread of misinformation and disinformation, and that their algorithms have basically compounded to this problem. He also discusses that they should be held responsible. The social media companies should hold some responsibility here in spreading this medical misinformation. The status quo is far worse. As my partner discussed, this past year has been a testament to just how dangerous misinformation is when it can reach such a wide audience. It grants something that seems so insignificant, like a tweet, a TikTok, or any other kind of these platforms, the possibility to create major conflicts at just about any level. Which is why people often question who's liable. When negativity comes from these platforms, this calls for accountability because these platforms are incubators for misinformation and the dangers that plague the United States. Thank you.
Thank you very much. Negative, you may now begin your cross-examination.
Thank you so much, Ariella, for that wonderful speech. I have a couple questions for you, if that's all right.
Yes.
Let's see here. So first, how would we determine what is and isn't in misinformation? in
What
the world of
is,
VF?
well, with that, we have a vast majority of research to check what is true and false. Right? If things are inherently lies and false information, this 230, if it would have amended, would help with that, right?
Okay. Why is Section 230 uniquely key to checking, to keeping these companies accountable for the misinformation spread on their platforms?
Because 230 is currently a roadblock in the solutions that could be possible here. We are seeing that these platforms are allowing for these authors to simply just put out anything, and with 230 being that piece of policy, we can enact change in that way.
Okay. So you argue that the status quo is far worse than a world in which we reform Section 230 to allow for civil liability for misinformation, right?
Yes.
Can you elaborate why?
I can elaborate because currently we have seen on January 6th that we saw that there was intruders, right? Our own American citizens were essentially going into the Capitol building and promoting violence. And this was through promoting violence through social media and So we are seeing that this is happening at the highest of level
Okay.
where people are going to the White House.
Okay, so my question is, what social media platforms were used to organize January 6th?
Twitter was definitely one of the ones used.
Well, what about Telegraph? Telegraph is a much more private form of social media that's kind of created an echo chamber. How would this
And
civil
that is your
liability
time
fall?
on cross-examination.
Okay.
All right. Negative, you may now begin your second speech.
All right, thank you so much. So far, this debate has been so wonderful. So I'm going to start right now. So the first thing I'm going to do is go into my first contentions and just a little bit of extension on that one. And then I'm going to go into the second contention for the negative and kind of extend a little bit more on some examples. So misinformation is inevitable. Billions of people use social media, and the affirmative is asking you to be able to get rid of misinformation almost immediately when it brings up. We can fight over how much misinformation comes up, and we can say that we're going to get rid of it, but every second somebody is posting something, and that could form into a bunch of misinformation with just the push of a button. So the biggest question is, how can we even get rid of misinformation if misinformation is ultimately inevitable? It is also extremely difficult to determine. You'll need to almost investigate every single case that has been published to make sure that is miscategorized as misinformation from the affirmative. By doing that, companies might just avoid that altogether because it's a little bit too much work for them to do. And instead, they'll do a censorship program like the negative has actually had to say. These companies with their censorship will actually have to go to a larger majority, which will possibly be bring to the Supreme Court, which is a bigger issue on its own, especially since this is under a First Amendment right case. There's an example that we can talk about with the contention too that the negative has brought up with the example of the civil liberty abuse, which basically is the liability of the multiple different things, such as the example brought up for the hashtag #MeToo movement. We can use that as a very specific example. It means that, like, for example, Twitter will be sensitive to the defamation claims. This means that the pressure that the platforms are being put to censure speech will start to censor the speech, which could hinder on people's First Amendment rights. This means that the immediate removal of the defamatory content will diffuse, quote unquote, the tension. This is decision exposition. It can continue the possibility of violence too as well if we are silencing those who are trying to speak out from the defamation claims. This issue can be arise such as things like sexual assault, labor rights, and violations, and ultimately silence those who are trying to use the platforms that are now being censored by these overt companies, trying to make sure that they aren't misinformed from those people. I can do on the contention for another example as well when we talk about censoring labor abuse victims. This is a very important case that came up. There's a very important case that came up called about Tyson. In 2021, there was a worker who actually died in their company while working, and instead of the supervisors removing the body, they actually refused to move it. Workers had to petition online to even get justice for this man from dying on site. And instead of them removing it, they actually worked 24 hours around the dead body before it was even removed. And the only reason it was removed is because they petitioned it online. If we get rid of this, the 230, the possibility of justice from public pressure could actually be continually eradicated and not being noticed by some people that are actually in harm's way from this being taken away. Affirmative is trying to tell you that they're trying to pinpoint, like on a dartboard, on what the possibilities of their solvency may or may not work, but aren't aware of the fact that if we do get rid of those people that are protected by those certain things might actually have a lot of social harms, which is a bigger issue of what we're talking about today. Where the formula that the negative is trying to say is that there are more issues when it comes to, or only more issues that this comes outweighs. That if the affirmative brings you all of those positive outsources, that it actually doesn't outweigh, and ours outweighs by a long-term. So the consequences for the affirmative are two long-term consequences, and the negative is trying to say that the ours are more, or our case is a little bit more to the sense and a little bit more helping everything, as well as focusing on the 230 corporate issue. So with that, you'll be siding with the negative by saying that we're looking at the bigger picture and trying to focus on more of who's the liability in the rights, and making sure that the violence isn't continuing when we're looking at defamation claims. Thank you.
Thank you very much, Kelly. Affirmative, you may now begin your cross-examination.
All right, thank you so much, Kelly, for that wonderful speech. I would just love if you could take me through a little bit of your links for a second. You mentioned the Me Too movement. Are you conflating Me Too with misinformation? How are the people who are posting their assault stories going to be like sued? How is this going to work?
Thank you so much for that question. I'll be answering on behalf of Kelly. I think that there's a little bit of confusion here, right, between what our link story is and what the affirmative has heard. First, it's not that sexual assault victims are spreading misinformation when they talk about their stories and when they expose those who have assaulted them. It's that misinformation as a claim is extremely vague. And that if you concede that every individual case of a flag for misinformation content is not going to be taken to court because there are way too many, there is a real possibility that those who wish to flag speech that's uncomfortable, speech that harms them, or speech that paints them in a negative light, they can just flag it as misinformation. And social media platforms will err on the side of caution.
I'm so
avoid
sorry to
lawsuit.
interrupt you, Aya. I truly am. But who is going to be the decider of misinformation when it comes to such a personal, intimate issue as sexual violence?
So here's that's the entire issue. There are thousands of people who suffer from sexual violence, and because the civil liability from quote unquote misinformation claims is so high, companies and corporations will err on the side of disbelieving victims, which is what our concern is, to save money.
Okay, thank you, Ariel. Yeah.
And that's time. I'm very sorry, Ariella. Negative, you may now begin your final speech.
I just want to thank everybody for attending tonight's debate. So today, there has been a heated discussion between the affirmative and negative teams regarding the affirmative's proposal to reform 230 to allow for civil liability with regards to misinformation. However, there's a couple of arguments that need to be addressed from the negative side that really clearly contextualize why this resolution and this proposal is a bad idea. First is the actual policy intricacies themselves. The negative team agrees that misinformation is bad and something needs to be done about it. However, we are debating about whether or not the affirmative plan should occur. And the negative team has decided, due to a view of a wide array of evidence from multiple legal scholars, that the reform to Section 230 to allow for civil liability for misinformation is simply too great of a risk for First Amendment rights and for the possibility of abuse of that civil liability system. This means when they try to argue that misinformation is bad, that isn't an argument for this specific proposal being key. It's just one possible solution, and we argue that it's bad because it can be abused. So our first contention specifically states that misinformation as a label that is extremely vague is extremely inevitable and extremely difficult to reconcile. Misinformation, whether we like it or not, is a First Amendment right. And when policies to limit misinformation are put into place, that brings about a challenge to the Supreme Court level that will either completely strike this down or risk expanding exceptions to the First Amendment that could have a disastrous amount of consequences in the future. Secondly, on contention 2, we specifically talk about how there are examples of civil liability abuse. Civil liability and as we call them, slap suits, are used to play down public dissent and public participation regularly in the status quo. Opening up companies for civil liability as a result of speech that makes people uncomfortable results in an abuse of that system. And that is not something we can risk in 2021. The beauty of social media is that it has given people a place for negative, uncomfortable critiques of the status quo. And the issue with presenting specific limits that are not nuanced to that specific term is that people will now be censored, and those who are committing real acts of violence can end up being protected and from uncomfortable speech that paints them in a bad light. The consequences outweigh any positive to the affirmatives plan is not necessary within Section 230 reform. Any positive they bring is outweighed by the long-term consequences to freedom of speech and the freedom of the press that we have in this country. Misinformation as a vague, inevitable term cannot be used as the litmus test for whether or not speech should be censored, because ultimately it can be abused by those in power to protect themselves, and those with the access and means to pursue civil liability can abuse our civil system to stifle uncomfortable speech. We agree misinformation is bad, but we need a nuanced solution. And whether or not that solution is presented by the negative team, that solution is obviously not found in the affirmative plan. The only option you have is to stick with the status quo. Thank you.
Thank you very much, Aya. Affirmative, you may now give your final speech.
As the last speaker in today's debate, I'd like to thank everyone for coming out and watching, and encourage everyone who may be interested to come join the Sacramento State debate team. With all that being said, the negative in their last speech spends several minutes talking about how they agree misinformation is bad, but that shouldn't be the litmus test. Well, the affirmative is the only team that has any propensity to solve the issue. The negative just gives you defense, which means if you think there is even a 1% chance that the affirmative is going to solve for the problem that we both agree on, then you have no choice but to prefer the affirmative. So let's go through it for quite a bit. My opponents make a good argument about how the First Amendment could be challenged through this, but ultimately this really boils down to the fact that the First Amendment has not, is not, and will not be absolute. As of right now, there are constantly different courts who are opining about how the First Amendment is put into practice. By implementing these changes to Section 230, we're not providing a path to censorship. In fact, we're simply strengthening the different systems that we have right now. I asked my opponents in CrossX if they thought that the banning of Donald Trump's Twitter account on January 8th was justified, and they agreed. If we're going to be taking these actions, Twitter as a private corporation and Instagram and all of these other companies have already had the responsibility of trying to protect the public from misinformation that could very easily turn violent. Our opponents agreed to this, and by amending Section 230, we're only by providing a much better pretext of actually providing help for the public. Again, this is going to help solve for things like inciting riots. If we can nip it in the bud before it happens, we ultimately are going to see a public that is much safer. Even if you don't buy that, let's get down to their slaps argument. Ultimately, this challenge doesn't really hold a lot of water when you bring into the pretext that no individuals who are bringing up issues of things like sexual violence that has occurred against them, they are not going to be the ones victimized through a lawsuit. I can assure you that Jack Dorsey, Mark Zuckerberg, or any of the other fat cat billionaires who run these companies can withstand it and have much better legal teams than some loser sexual assaulter. So ultimately, right now, this really isn't going to take up a whole lot of water. And it's very easy to see that these people are going to withstand abuse systems by sexual abusers. So ultimately, when we bring it back down to the affirmative arguments, they largely remain in place and largely remain the only type of system that can possibly provide any sort of solutions in today's round. We've talked about the fact that right now we're going to be seeing this as a stop to the incitement of riots. And as I said before, we can nip it in the bud and make sure that it doesn't happen before the actual violence happens. And it comes at a public health cost. The fact is, the COVID-19 pandemic itself is the biggest single impact in today's round. The fact that more than 750,000 Americans are dead are largely due to the facts that misinformation was spread from the very beginning of the COVID-19 pandemic. If we're going to take public health seriously, we're going to need to make sure that these public platforms are held liable to make sure that only the best information can get out to the public. Ultimately, right now, we've already seen a pretext for companies like Twitter to actually try and help the public. And we are simply, as the affirmative, trying to reaffirm that notion. So because of the fact that right now the affirmative is the only team that can provide any mechanism of solvency, and because the terminal defense arguments of the negative are simply not enough to overcome any chance of solvency, you have no choice today but to prefer the affirmative. Thank you.
Great work, everyone. Both teams really brought their A game tonight. If both teams would turn off their video now, please, I would appreciate it. Thank you very much, you guys. I wanted to reiterate, thank you so much to our debaters from the Sacramento State debate team for all their hard work tonight. We really appreciate it. And we also appreciate everyone at home who's joining us. Thank you so much. Make sure to let us know who you believe won the debate in the live stream chat. After all, you know, live results. We hope that you all have a great night. And if you're interested in what you see here, feel free to reach out to the Sacramento State debate team or your local speech and debate team, wherever you are. Stay safe, everyone, and have a good night.